They've stood at the front lines of law, leadership, and public service. From the courtroom to the classroom, Attorney Karen Jimeno brings sharp legal insight, academic excellence, and a voice that has guided national conversations. Attorney Mike Toledo, a seasoned public affairs strategist and legal mind with years in media, corporate leadership, and government reform. Together, they bring law to life with experience, integrity, and the courage to ask hard questions. Two minds shaped by the law. Two voices trusted in and out of the courtroom. This is ABOGADO.
Good evening and welcome to ABOGADO, where we dissect the law and discuss ideas that matter. I'm Attorney Mike Toledo.
And I'm Attorney Karen Jimeno. Tonight's issue is one that deeply affects every Filipino's sense of safety and belief in justice. This is our proposition.
In the past, it only took probable cause to bring someone to court. Now, the bar is higher. Under the present rule, prosecutors must believe there is reasonable certainty conviction before filing charges. Supporters say it protects the innocent by stopping weak or harassing cases from clogging our courts. Critics argue it blocks real victims from seeking justice, especially those without lawyers or resources, and gives prosecutors too much power. Is it justice or overreach? Tonight, we confront a question that strikes at the heart of every Filipino's safety and sense of justice. Should the stricter, reasonable certainty of conviction rule be removed from our justice system?
Joining us tonight, supporting the proposition to remove the more strict, reasonable certainty of conviction rule is Attorney Frances Jasmine Siapno, Senior Associate at Puno Law. She specializes in litigation and labor and has experience in commercial, energy, and family law. Attorney Siapno earned her Juris Doctor with honors from the Ateneo de Manila School of Law and holds a degree in Management Economics from Ateneo as well.
And opposing the proposition is a former ACRA lawyer himself, Attorney Jared Amoroso, partner at Kasimbing Torres Dispute Resolution Practice Group. He has 12 years of litigation experience with particular focus on criminal litigation and commercial arbitration. Attorney Amoroso is also the president of the Philippine Institute of Arbitrators and a seasoned professor of law who received the Dean's Silver Medal for his Juris Doctor thesis at the Ateneo Law School.
To get us started, here's a brief look at how tonight's discussion will proceed.
We begin with the opening statements. First, the speaker supporting the proposition presents their position in a focused 2-minute statement. Then, the speaker challenging the proposition offers their perspective, also within 2 minutes. The conversation then unfolds through two key subtopics. For each subtopic, the guest supporting the proposition presents their insights for 2 minutes, followed by a 2-minute perspective from the guest challenging the proposition. After both perspectives have been presented, we move into the open exchange, a 6-minute free-flowing discussion where both guests ask questions, share points, and respond to each other directly. Once both subtopics have been explored, we proceed to closing reflections where each guest is given 2 minutes to summarize their key messages. And finally, the hosts step in with their own questions. In this 6-minute segment, the guests respond, clarify, and deepen the discussion, ensuring no critical point is left unexplored.
And now we begin with our opening statements. The question: should the stricter reasonable certainty of conviction rule be removed from our justice system? Attorney Frances, you have 2 minutes.
Good afternoon. Again, I'm Frances Siapno, and I'm here to advocate for the affirmative position. Last July 2024, the DOJ circular it imposes a stricter quantum of evidence, which is the prima facie evidence with reasonable certainty of conviction. This quantum exists when a prima facie case is established by the evidence at hand, and such evidence is enough, if uncontroverted, to establish the elements of the crime. And this is the most important part. Subsequently, it should warrant a conviction beyond reasonable doubt. And the stricter standard should not be imposed because of three main points. First, the very definition of reasonable certainty of conviction is fundamentally inconsistent with the nature of a preliminary investigation, as suggested by its name, preliminary. And with the stricter standard, we are placed in a situation where, despite not yet being in trial, it's as if we already are. And this demands a near complete evidence at such an early stage. And second, the imposition of the stricter standard seeks to achieve the declogging of the courts and also to avoid the filing of frivolous cases. However, efficiency must not come at the expense of justice. And while conviction rates do matter, they must be balanced against the need to ensure that valid cases are not weeded out too early in this preliminary investigation. And there are also safeguards which can directly address these objectives without compromising legal and legitimate complaints. Lastly, the imposition of a stricter standard may create a conflicting ruling between the executive and also the judiciary. And for these three main reasons, the stricter standard should not be imposed at the preliminary investigation stage.
Okay. Thank you so much, Attorney Francis. Very well timed, within 2 minutes. Attorney Jared, your opening statement, no pressure, that it's within perfect time for Attorney Francis.
I will do my best. Our position is that the stricter reasonable certainty of conviction standard deserves a place in our justice system. I have three reasons why I think this is the case. Number one is that the Department of Justice was well within its powers in promulgating what is now known as the revised rules on preliminary investigation and inquest. It is well within its power because the law creating the National Prosecution Service does not prohibit and it does not mandate the probable cause standard that's been found in jurisprudence to be the standard to be applied in preliminary investigations. Number two, the Supreme Court's power to promulgate rules pertaining to pleading, practice, and enforcement and protection of rights is limited to all courts in the Philippines. And it has been recognized by the Supreme Court itself that preliminary investigation is a process that is solely within the control of the executive department. So if the question is, can the Department of Justice issue a circular that changes the standard to be observed in preliminary investigation cases, the answer is a resounding yes. The second reason why I think the reasonable certainty of conviction standard deserves a place in the justice system is that it doesn't pose issues to access of justice. It is more consistent with the protection of the rights of the accused enshrined in the Constitution. Access to justice is access to meaningful justice. I don't think it is meaningful access to justice if a criminal case will proceed in the preliminary investigation stage only for it to be overturned and the accused declared acquitted by a court. And then lastly, why should it remain in our justice system? Because so far, all indicators show that it works.
Okay. Thank you so much, Attorney Jared. Now let's move on to our first subtopic. This is about access to justice and case quality. Is this higher threshold improving justice or restricting it? Attorney Francis.
Okay, so I think we have to go back to the intent of the circular itself. Last 2020, the conviction rates in criminal cases was 25%. And according to Attorney Jared, the numbers have increased, the criminal conviction cases up to 76%, I think. However, a higher conviction rate does not equate to a more just system. It may simply mean fewer cases are being filed because there is a higher threshold. But because the bar has been raised so high, fewer victims are being able to reach the courtroom. It does not necessarily mean that the system has become more just. Maybe it has just become more selective. And in People versus Figueroa, the Supreme Court ruled that the nature of a preliminary investigation is not for the full exhaustive display of your evidence, the party's evidence. And the investigation before the prosecution is deliberately named as preliminary. So should be proceeding and not to overtake the trial court proper. And consequently, real victims also can't present full evidence immediately, especially in crimes which are complex and also in crimes which have a delay in reporting time, such as sexual abuse or corruption, and thus limiting the access of justice and favoring the legally resourced and also powerful. And considering, for example, if people believe that the justice system only entertains cases which are near completion or which have already been built up, then there's a possibility that they will be prevented from actually filing cases. So my proposal is there are other ways to address this, such as without compromising the legitimate complaints. So the DOJ has actually implemented already a work towards digitalization and also the case build-up strategy, both with the legal law enforcement and also the prosecutors.
Thank you so much, Attorney Francis and partner. Just like Attorney Jared here, they're both really sticking to the time.
Yeah,
That's
very impressive.
Very impressive. We can really argue so well in the time allocated. I do recall, though, that the DOJ said that, in fact, that's according to them, 93% rate of conviction now because of the allegedly the changes. But you know what, partner, before I give to Attorney Jared the floor, what entered my mind while they were discussing these things, it reminds me of our ongoing shows or episodes on impeachment, wherein there's a talk about when should the evidence be? The trial should be in the Senate. The House is not. They're just initiating. The Supreme Court's not a trier of facts. So to a certain extent, there's some similarities to this issue. Yeah. Anyway, Attorney Jared, your view on this?
Okay, I agree with Attorney Francis with regard to the purpose of the DOJ circular that imposes this stricter reasonable certainty of conviction standard. The question is it hampering access to justice? I think when we view the stricter reasonable certainty of conviction standard that's embodied in DOJ circular number 15, we need to take into account the other procedural rules that were put in place by the DOJ in coming up with the rules. What are these procedural rules? The procedural rules are, number one, if the case is dismissed for failure to comply with the standard, which is reasonable certainty of conviction, the case can actually be refiled. And then number two, Attorney Francis mentioned case build-up measures. That is an innovation in our rules on the criminal procedure under the DOJ. Why is it an innovation and why is it something that addresses access to justice? Because litigants are not actually prevented from going to the DOJ and filing a criminal complaint. What the rules envision is that if someone goes to the DOJ to file a criminal complaint, the DOJ prosecutors are tasked to proactively advise the complainant on what evidence is missing. And then number three, I don't think that there is an issue on access to justice because the preliminary investigation stage, according to the Supreme Court, is not even a quasi-judicial agency. It is a purely administrative function, and the DOJ directing how parties before it file complaints and what it should see is purely within its prerogative. The parties can still file, they can still pursue criminal complaints, except that the DOJ wants the criminal complaints to be of a sufficient level so as to be closer to the proof that's required when the case reaches in court, which is a reasonable ask, if I were, in my opinion.
Okay, thank you, Attorney Jared. Now, let's open the floor for a 6-minute exchange. Attorneys, you may respond, rebut, or clarify with each other's argument.
Okay, so may I go ahead?
Yes, of course.
Ladies
Yeah.
first.
So I noticed that you said that there's no hampering of justice and they still have access to justice. While I do agree with that, we should take into consideration that we are in a Philippine setting. And I would say that a lot of the litigants and a lot of the complainants who are victims are actually part of the marginalized sector. So although we can refile eventually, we also have to take into consideration that these litigants, once they file something, that's all their resources. And after that, if you tell them, oh, we have to deny it because of this and that, then they would be disheartened. And even if there is a remedy to file, they might still be limited because of their resources. So what is your take on that, Attorney Jared?
That's a very good point, Attorney Frances, and I do see where you are coming from. My take on that is that I don't think that justice would be achieved or that it can be considered meaningful access to justice if a complainant who doesn't have enough resources would have a quote-unquote victory in the preliminary investigation stage. But as lawyers, we know that the criminal prosecution process in the Philippines is actually a two-stage process generally. You quote-unquote win at the preliminary investigation stage, only to what? Have the case dismissed at the outset when it reaches the court. Or after a lengthy trial spanning 3 or 5 years, the court would find and acquit the accused because of lack of evidence. So for me, even from that perspective, I think the DOJ imposing stricter standards at the preliminary investigation stage, in fact, helps litigants who don't have much to begin with in pursuing justice in the form of criminal proceedings. And then lastly, I think when we are talking about access to justice, I think we should also consider the perspective of the individuals who are accused of the crimes. I think access to justice for them would be a situation where they are prevented or they are isolated from the criminal justice system, which is a very scary prospect. Imagine the entire power of the state moving against you. So it's being isolated from that process when to begin with there is no evidence. Because I don't think that a meritorious case should be equated to a case that makes sense but doesn't have evidence. Because how the justice system works is a case is meritorious if there is evidence to support the allegations.
And
Please,
can I-
yes, please,
This
yes.
is a free-flowing discussion. Yeah.
So, but the question is, do you really need a new standard in order to do a case build-up? So, for example, when you file a case, and let's say the standard is still probable cause, it does not prevent the prosecutors from building a case. Even before the filing of a counter affidavit, under the new rules, the NPS rules, the prosecutors can subpoena documents, witnesses. So you can actually still build a case with the standard of probable cause, and it will be material when it goes to the court. It's just that the standard does not change. So why is there a need to change the standard when you can still build a case? And this benefits both the accused and the litigant.
Good points to raise.
Yeah,
Attorney
another
Jared.
good point. I think the best way I can answer that is perhaps from the perspective of the DOJ, what they really are looking at are the case statistics. And Attorney Mike earlier mentioned that according to the DOJ, of course it's according to them, there's now a 93%
93% conviction rate.
You know,
Yeah.
we can appreciate it more when we realize where it was coming from. You know, according to the DOJ, before that, the average conviction rate barely hits 26%. I actually did a bit of digging. Maybe that's a bit overstated, but at least from 2016 to 2020, the conviction rate was 48.59%.
But that was before the circular took effect. So
Right.
are we certain with the data that this new circular has something to do with the higher conviction rate?
That's a great point, Attorney Karen. And I haven't seen the source document, but the DOJ as well says that in July of 2024, it reported a 93.59% conviction rate in cases filed before the trial courts from second quarter of 2023 up until the first quarter of 2024. Why is the second quarter of 2023 important? Because even prior to Department Circular 15, the reasonable certainty of conviction standard was introduced in prior circulars, and that was in the second quarter of 2023. So what the data seems to show is that there has been a marked improvement in conviction rates when the reasonable certainty of conviction standard was
But that usually it takes so long from the time you start a case until you reach a conviction, even at the lower courts, regional trial courts. So I'm curious if that really reflects, a new, that the threshold, with a higher threshold, that it really led to higher conviction rate.
I share the same sentiment because I haven't seen the source data as well.
Yeah.
But I think what's happening there, partner, not taking any sides, of course, because
Yeah.
we're moderating. It seems that these circulars, if we follow the data, has really shown that they were able to control the quality of the complaints filed. In other words, at the outset, if the information or the affidavit, the complaint is not sufficient enough to really warrant a possible conviction, they would rather take it out and weed it out immediately. And thus, the argument goes that the case becomes stronger. Mas malakas na yung kaso kasi parang bang
Na-weed out na
tinignan mo
nila.
talaga yung mga mahina,
Yeah.
saka lalo na yung mga tinatawag nating frivolous or malicious cases na paninira lang. Which, by the way, isa pang gusto kong ipasok siguro sa discussion. No? At the end of the day, sometimes, pag na-file ka ng kaso, maski na maging inosente ka after years of trial, the fact that a case has been filed against you and you have been pilloried in media, medyo sira na talaga.
Yeah.
Yun
And you
yun ang
get a
masakit.
stigma already,
And you get a
no?
stigma
So
already.
the consequences are
Oo,
grave.
oo. Well, anyway, again, no, the partner, talagang it's good to have brilliant lawyers discussing
Yeah.
a legal
And they
point
both
like
have good
this.
points, yeah.
Exactly. That's why it's really hard at the end of the day. Somehow we can also ask our audience in the future, who do you think won? But
Oo nga
maybe
eh.
that's something
Next time,
it's something we could consider. Now, anyway, now let's address the issue of legal authority and institutional boundaries. Now, Attorney Francis, do you think the DOJ has the power to impose this rule unilaterally? There have been complaints saying that this is actually just like judicial overreach in the impeachment cases. This is a form of overreach by the Department of Justice because they're saying, how can the Department of Justice amend a statute? How can the Department of Justice amend Rule 112 of the Rules of Criminal Procedure?
Okay, so for that one, Attorney Mike, I think we also, again, have to look at the resolutions made by the Supreme Court. I think there's no argument that the preliminary investigation is really under the umbrella and the jurisdiction of the DOJ. However, in the resolution passed by the Supreme Court just last year, they said that although they have the authority to impose a stricter standard, the courts still have a separate mandate and also jurisdiction, which is the rules of court. So this just results in an absurd situation wherein in the prosecutorial offices, you have a stricter standard, you have a higher standard. And then when it comes to the courts, you will have a lower standard, which is probable cause, to issue a warrant of arrest. So in that case, in order to avoid this absurd situation, there really has to be a collaboration between the executive and the judiciary in order to streamline the procedures and in order to be aligned with the standards that they are imposing. So, for example, let's say a person who makes it through the preliminary investigation, and then when a complaint or information is filed in court, the court will decide that there's no probable cause, then it would leave the litigant in a tricky situation and also leave the litigant confused, the people confused, like why why was my complaint dismissed when I was able to prove my case in the preliminary investigation stage. So it might not be a direct attack on the DOJ because they were authorized to issue such circular, but it does encroach on the power of the judiciary to determine cases covered by probable cause for warrants of arrest.
Okay. Thank you so much, Attorney Francis. And Attorney Jared, you've touched upon this earlier in your opening statement, that this was within the discretion and authority of the Department of Justice. But perhaps you can add more to your arguments as to why this reflects a legitimate prosecutorial discretion on the part of the DOJ.
Right. Thank you, Attorney Karen, and thank you, Attorney Francis. The reason why I say that the imposition of this new standard is a legitimate exercise of the power of the Department of Justice is because, number one, the Supreme Court itself has recognized this power. I agree with Attorney Francis, that the best way to do this would be for the DOJ and to the Supreme Court to coordinate. And in fact, in a resolution in May of 2024, this is an NBank administrative matter number 240209-SC. It could be seen that the Supreme Court actually made way for the DOJ to promulgate its own rules. How did the Supreme Court do this? The Supreme Court expressly mentioned that Rule 112 of the Rules of Court, which as we know is the rule on preliminary investigation, will be deemed repealed insofar as it contradicts provisions of the DOJ's rules on preliminary investigation and inquest. In that resolution, the Supreme Court in fact narrated how the DOJ even wrote the Supreme Court commented on the rules, and after that, the Supreme Court, through the leadership of the Chief Justice, referred it to the Supreme Court and Bank. And then the resulting resolution was, number one, an acknowledgement that preliminary investigation is indeed within the ambit of the executive department. Number two, the concept of probable cause has actually been evolving since the rules of court in 1940. And then lastly, what I want to point out here is that none of the laws that govern the National Prosecution Service require that the standard be the lower probable cause standard. And that's where I'm coming from. When the DOJ legitimately issued this higher standard in preliminary investigation stages.
No, thank you. Thank you so much, Attorney Jared. Now we open again, partner, the floor for a 6-minute discussion. Would either counsel like to open exchange? Since you started earlier, perhaps let's be fair, equality among gender, although chivalry is still alive in the studio. But Attorney Jared.
Yes, ako po, from my perspective, the way I see it is people have been clamoring for a long time. We need to change the system. We need to change the system. And then suddenly, in late 2022, 2023, DOJ comes up with, you know what? We should change the standard in determining whether cases should go to court. We should improve the quality of cases that prosecutors handle. We should involve the prosecutors in a proactive case build-up mechanism. All of these have been instituted in such a short amount of time, and it looks like there are results. And to me, the fact that the DOJ consulted with the Supreme Court in coming up with its rules, I think is a very, very good step which provides legal clout over its actions. And I feel that's why I feel strongly about the legality of what the DOJ did.
Yeah. Well, Attorney Jared, if I may interject. So I agree with your point that they at least became proactive in changing something with our judicial or legal system. But what about the issues that we face from before as well that contribute to making the justice system ineffective, which would be the vulnerability of our system to also favor those who have money. So when it comes to filing cases, those that can advocate for themselves with yung lagay-lagay. I think we can be open about that as lawyers, di ba? Nangyayari naman talaga yun. So, usually, yun yung na-file na kaso. At mahirap din ma-dismiss yun pagka may nakausap na at the DOJ side sa prosecutors, Office of the Prosecutor. And baliktad din naman, pag let's say kahit malakas yung kaso, pagka meron ka nakausap, madidismiss naman. So, how do we address that?
Okay. Thank you, Attorney Karen. Ako po, ang perspective ko dyan, the introduction of a higher standard for filing criminal cases in court may actually serve as a deterrent to all things that are extra legal. Why do I say this? Because now, in a way, the way I see it, in a way, it has a way of leveling the playing field. Because now, no matter how much resources you have, the prosecutors are in many ways directed to take a look at the evidence more closely, to scrutinize it as if they will already try it. And with that kind of system, I think it is more difficult to file cases, to have criminal cases filed in court purely because of power, purely because of money. It will all depend on the evidence and the quality of evidence. That to me is a positive effect of the new standard insofar as issues on corruption is concerned.
I think, Attorney Francis, it's your turn to refute, rebut, clarify.
I do agree that there has been a significant change in the rates and the statistics that we've been discussing. However, as I've mentioned previously, justice is not just measured by statistics. It's measured by the experience of the people on the ground in the Philippines. And as I said, the setting in the Philippines is really, a lot of the litigants are marginalized. And does it really require, is it really necessary to change the standard when all we have to do really is to change the system and not the standard itself? It's just the fact that the prosecutors can work together with the law enforcement agencies now. It's the fact that the prosecutors can subpoena documents now even before the counter affidavits are filed. So this is actually a great deterrent and a great rule that the DOJ has already imposed. And it really isn't necessary to change the standard, just the procedure that affects the filing of these complaints and information with the court. And to add to that also, again, we have to see the collaboration between the executive and the judiciary. I think we can all agree on that point.
And also the skill level, right? Like the ability to determine whether it's really, for example, if we go back to the old standard, whether there's really probable cause or in this case, reasonable certainty of conviction.
Yes. Can I still say something?
Of course.
Please,
We're
please.
still within the time of our
All right.
issues. Yeah.
No, I agree with Attorney Francis. I would like to add that the higher conviction rates really means something if you really think about it, because the converse is that there's lower conviction rate. And what does a lower conviction rate mean when we take into account that conviction rate is counted on the basis of cases being filed by the prosecutor's office in court, and then courts acquitting or finding that they are guilty. A lower conviction rate means that there's a lot of people who went through the hassle of a criminal proceeding for years and then end up with the court saying they're not guilty. So that is the real and very human value of making sure that cases that reach court are cases that actually have merit based on evidence.
And it is more just for either the complainants as well, but also for the accused. Like you said, nga, partner, diba? It's so damaging. So if you went through years of trial only to be acquitted eventually, pero yung stigma for so many years, right? So
And the sad part, and if I may just put it in, I've had the chance to represent big cases in the past when I was actively practicing law, criminal cases. And the thing is, when you are, let's say, indicted, and then you go to trial, it's the headline. But when you're acquitted, swerte na lang kung meron kang maliit doon na, na-acquit pala. Pero your reputation has already been damaged. But that's the sad reality of the kind of world we live in now, wherein the information travels really very fast. Then again, that's
Ang
how it
bilis
is.
lang nung natapos nung 6-minute exchange. But for now, we'll have to take a short break. When we return, our guests deliver their final reflections on tonight's proposition. This is Abogado.
Welcome back. You are watching Abogado. We've heard two compelling sides on a technical but impactful issue. Should the reasonable certainty of conviction rule stay or go? We are joined by Attorney Francis Jasmine Siapno, Senior Associate at Puno Law, who argued strongly, if I may say, in favor of removing the stricter rule. And of course, we have Attorney Jared, Amoroso, who also argued very strongly. He is a partner at Quisibing Torres and defended very well, if I may say, the retention of such in the justice system.
You know, I just realized, see, Attorney Jared, nag-involve siya sa law firms that we both work in. You from Accra, and then now Quisibing Torres, which I was also a part of before.
Yeah, exactly.
Yeah.
We can, in fact, I was telling him, let's share some horror stories.
Oo nga, I'm curious now how you run Quisibing Torres.
Beyond 6 minutes.
Yeah. Now we
Okay.
turn to our guests for their final reflections. Attorney Francis, we begin with you.
I think the main issue in the whole discussion is the statistics. But again, the 25% rate, how is it computed? So the case disposition rate is computed by dividing the total number of decided, resolved, and archived cases by the total number of pending and newly filed cases. So let's take into consideration that in 2022, the 25% rate was based on the DOJ has not issued the rule on case build-up strategy. There has been no rule on the video conferencing. So we should take into consideration that the increase in the 25% is not only attributable to the change in the standard, to a stricter standard. In fact, it is because of the efforts of the DOJ in the other aspects of preliminary investigation and how they conduct their the prosecutorial offices. And also, again, the disposition rate is also important, but it is not the whole measure. That is not the sole basis and the measurement of whether a system is efficient and is just. So the fewer cases filed, which is taken into consideration in the 25% statistic and the 96% statistic, only takes into consideration the newly filed cases. Now we have to really reflect on this. Why are the newly filed cases lower? Because there might be a chilling effect that is brought about by this new stricter standard. When in fact we can stick with the probable cause standard, but still keep the other innovations that the DOJ has already established, like the case build strategy, and also the digitalization of the whole procedures with the preliminary investigation. And thus, it is really not necessary to change the standard to reasonable certainty of conviction.
Thank you, Attorney Francis. Your closing reflections, Attorney Jared.
Thank you. I think what the DOJ did when it overhauled its rules on preliminary investigation, inquest, introduced new modes of investigation. You have now the expedited preliminary investigation and then summary investigation, now explicitly spelled out. And throughout all of those things, you have the DOJ saying that, wait, now we have a higher standard for filing cases in court. I think it is a very good thing that the DOJ did. It's well within its powers. I think, and I might be backpedaling here for a bit, the case statistics that we have now are, I think, maybe not entirely reliable in terms of painting the entire picture. The DOJ Circular Number 15 actually celebrated its first year anniversary this July 2025. It's still very early to have conclusive thoughts about whether the increase in the standards does this or does that. But what does the statistics say or convey? For me, it at the very least conveys that there is an effect in how cases are being resolved at the trial court level. And I think it's important, very important, to consider that a criminal case is special. It's not a civil case. It's not an administrative proceeding. It is a criminal case where the people of the Philippines is against an individual. And that is where the Supreme Court has in fact ruled that it is better for one guilty person to go away, to be set free, than to imprison
One innocent
person.
Yeah.
I may have messed that up. 1,000
But we
guilty
get
persons.
we get
the
it,
point.
yeah.
But all those presumptions and rights in favor of the accused all boil down to the fact that a criminal case is very, very unique. It is very oppressive against an individual. What the DOJ does in ensuring better prosecutions is a very welcome development.
Okay. And sayang, we're out of time.
Yeah.
So right now, we'll just have one question each. That's all we have time left for. So for me, I just have one question because we are here debating about this new standard imposed by the DOJ, this reasonable certainty of conviction, in order to even file the case for it to reach trial, right? But my question is, do you think that this standard is really meaningful given the realities of our justice system? Meaning, when we talk about probable cause and then this new standard of reasonable certainty of conviction, palagay nyo ba talagang meaningful siya in terms of implementation? Or does this still boil down to the level of discretion at the executive level, meaning at the level of the prosecutors, wherein you may have a prosecutor that is still allowing the filing of cases even if the threshold is probable cause, kahit tinatawag na natin siyang bagong stricter standard. Is it really a meaningful change?
Well, for me, it might be meaningful, but it's not the most meaningful thing that we can actually change now. So there are a lot of procedural aspects that we can still improve before we even get to changing the stricter standard. Like what Attorney Amoroso has brought up, the case build-up strategy and the other circulars that the DOJ has already implemented is really helping the justice system. So in that case, why don't we build that up? Why don't we improve on those procedural aspects first before we get into changing the stricter standard?
Quickly, Attorney Jared?
For me,
yeah?
for me, the shift to a stricter standard is meaningful because it cultivates a change in prosecution culture. It cultivates a change in the mind of litigants. And more importantly, it changes the perspective of us lawyers when filing criminal cases. In so many words, hindi pwede yung pwede na yan, papasa naman sa piskalya. Bahala na, saka tayo magsipag sa court. So, a change in attitude is always a welcome addition to the justice system. It invites challenges to the prosecutors and to the lawyers.
Yeah, you know, partner, my take. I don't really have a question anymore,
Yeah,
except
so
that
I guess
perhaps
you can give us your take.
Yeah, just that my take. I think it's really a balance here. It's a balance between efficiency, which means well, but at the same time a balance vis-a-vis or versus rights. So how do we actually balance that? And I think you both discussed it. Perhaps the Supreme Court, the DOJ, they should be talking because the point that she raised was very good. For example, they find that the higher standard is enough for the filing of a case, but the court says no, we cannot issue a warrant of arrest, because to think that the level in the courts is even lower because it is probable cause. So I think this should be further studied. Pero partner, just as a final take sa akin, ako depende, no? Kung nasa respondent ako, kaya Attorney Jared ako.
Oo, kasi mas mahirap mag-file. Pero if you're representing clients na complainant...
Kung ako naman ay nasa complainant, kasi I have a chance also in the past to be private prosecutor, di ba? Under the direct control and supervision of the honorable fiscal. Di ba? Yan ang mga standard lines natin, di ba? Then, doon naman ako sa kabila. So, but that's levity aside, of course.
Yeah, that's true. But it would be interesting to see years later, from the time this circular was passed, where we can see a correlation talaga.
Right.
Whether
Yes.
they have improved the
Exactly.
quality of the decisions and yung disposition of cases.
Maybe
in
we
court.
should have them in about 6 months' time again. Revisit. Maybe by that time we'll have more data.
We change position.
And then you change position.
Thank you so much, Attorney Frances Jasmine Siapno of Puno Law and Attorney Jared Amoroso of Kisumbing Torres for lending your insights tonight.
Yes, thank you so much. When we confront complex legal reforms, we must ask not just what the law says, but what justice demands.
That's the mission of Abogado, to bring clarity, spark discourse, and uphold the value of reasoned debate.
This is Abogado. Good night.